Hi, my name is Frank Stiff, and I'm here today with David Snead in what is hopefully the first of a series of videos about buying and selling hosting and other internet services businesses. David is a leading attorney in the space with well over 10 years of experience working with both large and small providers across a range of legal issues. He's also co-founder of the Internet Infrastructure Coalition, the trade group for the Internet Infrastructure Services companies. I'm an investment banker that helps companies buy and sell other companies, raise money, and perform other financial events. Links to both our firms can be found below for more information. I do want to highlight that our comments today are for general information purposes only, not meant to be taken as financial advice or legal information. This is not meant to be a recommendation to buy or sell companies. It's not a comprehensive discussion of the risks involved. So please be sure to consult your legal or financial advisor when considering the purchase or sale of business. Lastly, just to be sure there's no confusion, neither David nor I assume any responsibility or liability for the information in this video and may deny that we are ever in it. So David, the point of this video, among others, is to talk about selling a hosting business. Okay. And so we're going to try to answer today just what the steps are. We're not going to get into a great deal of detail. But let's just start off at the top. What is it for you, the first step, if a company wants to go and get ready to sell their hosting business?
So there are two ways of answering that question. The first is, what is the first step in terms of a company deciding that they want to sell their business? And the second answer is first step legally. So let me start out with the first step from my perspective, that a company has to, particularly a hosting company, has to think about when they're deciding to sell their business, and that is they have to decide why they're selling. And I don't believe that a successful transaction starts with a company saying, let's just put ourselves on the market and see what happens. I think that there needs to be, for my clients who have successfully sold their businesses for an amount that they believe fairly reflects their value, they've actually been thoughtful about the process, about why they're selling. So that's kind of the first emotional hurdle, or the first thing intellectual thing to think about. From a legal perspective, the first thing to think about is, are we ready to sell? What do we need to go through legally to figure out how we're going to get our ducks in a row in order to prepare for a sale?
And are there any particular legal issues that typically crop up when a company is thinking about selling?
Sure. The first and most important thing is, have you done everything that you are required to do from a corporate status perspective in order to sell your company? I have had at least 3 transactions fail at the very end simply because my clients had not been maintaining their record books, had not been having meetings, and at the end of the day, when we got to the figuring out how to get the transaction approved, it was just too much of a burden for them to go through all of the paperwork to get themselves on the right track. So from a legal perspective, you just need to either engage your corporate counsel or engage someone to help you get your corporate status settled. You need to be in good standing. You need to have had all your meetings, depending on what your corporate status is. You need to have a minute book that reflects that, and you need to be in a position where you know who all your shareholders are, how much they own, and what is required in order to get them to approve a transaction.
All right. You know, it's from our standpoint, it's similar in that the way we look at it is, once you start a transaction, you don't want to have to stop partway through it to go find something out or to go fix something. Because transactions have a momentum. Once you have several prospective buyers interested in your business, you'd like to make sure that they keep moving forward and that you don't have to stop the whole process for 2 months while you figure something out. So for us, another key part of the initial step is to make sure you can answer the basic questions a buyer is going to want answered. Questions about your business's profitability, questions about its size, customer stability. And these things are really pretty straightforward. A good set of financial statements does a lot. A good set of figures as to how many customers you've been adding and to losing over time helps out. How good is your marketing? These are all kind of basic parts of information that's very helpful to make sure you have up front. Because sometimes when you get into a transaction, it can take a few weeks to pull some of this stuff together if your systems aren't in good shape. So those are kind of the big preparation step from our end. I guess as you're ready to get going, the next step, of course, is to start trying to contact prospective buyers or to find interested parties. I think we're going to skip the interested party discussion for another time, and that can be a fairly lengthy conversation about how you go about finding prospective buyers. So let's say you fixed your problems internally, you're ready to go, you have all your data lined up, you've got 4 or 5 interested parties you want to approach. What's the first step?
So the first step is honestly not a legal step. I would say that the first step, once you've got all the parties lined up, is your lawyer should not be the one piggybacking the transaction. That should be your financial advisor. What you should have in your pocket, however, is your own letter of intent. Because unless you're dealing with a very sophisticated buyer, once you start negotiating or start talking to potential buyers, people are just going to ask you for a letter of intent, where you can just provide one for them. If you have your own letter of intent, there are 2 advantages to that. One is it really shows a level of sophistication to potential buyers that you are committed to the process. The second is that if you have a letter of intent written by someone who routinely engages in transactions, your letter of intent is not going to be 65 pages long. It's going to be a very concise letter of intent, and it is going to adequately protect you. One of the things to understand about letters of intent is there are a couple of places in transactions where companies are really susceptible to claims and litigation, and one of them is at the letter of intent stage. So you're going to want to have a letter of intent that's been vetted by your financial advisor, vetted by your lawyer, so that you are not putting yourself in a position that you're going to be susceptible to a claim, for example, that you had committed to exclusivity with a particular buyer when in fact you were negotiating with multiple buyers.
All right. Well then, okay. So then we've got a draft LOI ready to go from when we get an offer. We probably also need a confidentiality agreement, and then I think you're ready to start contacting buyers. And again, there are those of you out there that are going to do this themselves. Perhaps you know somebody that you think would be a good buyer for your business. If you have a financial advisor, they'll probably contact people on your behalf. So the next step where you're contacting prospective buyers, the first thing you're going to do is to sign a confidentiality agreement with them so that all your information stays confidential and they don't go blabbing around to your customers that you're selling the business. Once you're through that, then you get to the stage where you're going to share information back and forth. And there's a variety of goals in this part of the transaction. The buyer's goal is he was going to want to know how much cash your business is going to generate for him when he owns it, and what the risk is that cash is actually going to occur. If your business is generating a lot of cash, but the buyer looks at it and thinks it's all going to go away in 6 months, you're not going to get a great offer for your business. The seller wants to know if the buyer has the resources to complete the transaction. Obviously, you want to know that the buyer has the money to pay. You also want to know that they've got the capabilities to complete the transaction. And by capabilities, it's in your goal as a seller to have a successful transaction. If the buyer buys it and then 4 days later crashes the entire infrastructure because they're not competent, the odds are that the transaction is not going to turn out to be successful for them, and before they blame themselves, they're going to try to blame you. And I think both sides want to make sure they're dealing with a good partner, so they're, both you and the buyer want to go back and forth to make sure you're a good partner to do a transaction with. And remember, at this initial stage where you're sharing information, the goal is to get to an offer. The buyer is really supposed to, or really should, accept the data you give them as being accurate. They're not to be doing due diligence on every piece of data that you give them. They'll do that later. But the first goal is really, let's just get to an offer as quickly as you can without wasting a lot of time and effort of everybody involved. And so at that point in time, hopefully, after talking with a few prospective buyers, you found at least one or hopefully more prospective buyers that put an offer on the table. And one has called you up, has given you a price, and you think that's a good price. And so at that point, you either talk to your financial advisor or you call your legal advisor on the phone and say, okay, now what? David, I think you're now what?
So this is after you get you get the offer, and you've negotiated on the price, and you begin to do generally a dual track type of work, and that is due diligence and negotiation of the asset purchase agreement. One of the things that you should do when you're beginning to prepare for any transaction is anticipate what due diligence is going to entail. Due diligence is something that the parties have to do themselves. It's not something generally that your lawyers or your financial advisors can help you with. You need to find all the contracts that are relevant to your business. That includes contracts that you have not seen in 10 years. You're going to be asked for those contracts. And if you can't find them, or if the vendor, your contact is gone, you need to come up with a credible explanation that can be verified why you don't have that information. The same is true for information about your business that is less than flattering. In due diligence, nobody expects a company to be perfect. For example, nobody expects a company not to have had some employment claims or claims of that nature. The important thing is that you've prepared an explanation that is accurate, that is believable, and that is already reflected in your negotiations. So you don't want to wait until due diligence to, for example, let the prospective buyer know that you've had several patent infringement claims. Because that's a hurdle that's often those kinds of litigation issues are hurdles that are often difficult to overcome in due diligence. So going on parallel with your due diligence is negotiation of the purchase agreement, whether it's a stock purchase agreement or an asset purchase agreement, that will underlie the negotiation. And this the negotiation of an agreement is tedious, but it's completely it's very important, and you need to understand all the provisions that are in your agreement, and you need to have your financial advisor and your lawyer explain those provisions that are in your agreement that you don't understand to you in a way that you can understand them. Because at the end of the day, this is your document, and you're going to have to live with it. If you don't understand something in it, and it is something that's detrimental to you later on, you won't be able to excuse your non-compliance or the problem with that provision by saying I didn't understand what this was when I signed the agreement. So those are kind of the parallel tracks. The other piece that I would tell clients about the final agreement is there's going to be a series of schedules that are attached to the agreement. Those are issues that you're going to have to prepare yourself. Your lawyer and your financial advisor can't prepare your schedules for you. Those are going to be things like you're going to need to know all your domain names, you're going to need to know all your trademarks, those types of business issues that you need to start thinking about during this whole process.
Well, yeah, I'd love to add to a few things on that. I really agree about the bad news. We find that if you tell everybody the bad news on day one, it never is an issue. If people find out the same bad news in due diligence, in other words, you didn't tell them, it can derail a transaction. And it often does derail a transaction because sometimes the buyers may not be sympathetic to the argument that it was something that happened long ago and you forgot about. So bad news, always disclose bad news first. The other thing I want to highlight about the purchase agreement negotiation is what David talked about earlier. By having a detailed letter of intent that was pre-prepared and that you used to memorialize the offer that you got from the buyer, that'll have a lot of the key purchase agreement terms in it. Things like non-compete, things like holdbacks. If those are in the letter of intent, then the asset purchase agreement will be a lot less of a surprise. You really don't want to get a document that has a whole bunch of new terms in it that you never heard of or thought about. Because the old expression is that, you know, the big print giveth and the small print taketh away is sometimes true in the APA. I also want to say that two other things. It is not a fun process. It's not the process that one looks forward to like a summer vacation, but it is a manageable process. The most painful part is probably reading the agreement every time your attorney sends it to you, which will be 10 or 15 times. And once you
twice.
Twice. Once you read it the first time, which will be the most painful, it becomes pretty straightforward. And so I think those are the major steps. There's a couple of issues I'd love to just to highlight. One is time management, and this is important. You can't stop running your business because these processes can take 30 days or 60 days or even 90 days to complete. If you stop running your business and the financial results start to deteriorate, the buyer may back away at the last minute if your revenue starts going down. So you really need to keep paying attention. And I know it's self-serving for David and I to say it, but there is a lot of value to be gained by hiring experts along the way. If you know somebody that really wants to purchase your business, then hiring somebody like me and having a good attorney like David would be all that you need. If you're looking to approach a wide variety of people who you may or may not know, hiring a financial advisor, and there's a number of very good ones in the hosting business, hiring any of the financial advisors to help you on your path could really add value to business. David, do you have any other comments you'd like to make?
So I agree with your comment about the length of the process. One of the pieces of advice that I give to my clients when I initially talk to them about working with them is that the process is going to take longer than you think. It is going to be more emotional than you would imagine, because for most small and medium-sized businesses, you have relationships with people that you're going to need to consider, and so there's an emotional scope to it. And the third thing is that you need to trust your advisors and disclose and talk to them honestly about what your expectations are and what is going on. We can't negotiate for you if we don't have the full benefit of your experience and your emotion. The other thing that I would say is, I really do want to emphasize the importance of getting the major terms for your transaction, the major expectations for your transaction out there to start out with, and make sure that if you have expectations that are more than a dollar amount, that you communicate those to your broker or to your lawyer. For example, if you expect to some of your key employees to remain with the company, you need to get that stuff out there. It can't be put in at the back end. At the end of the day, it's your company. You're in charge of the transaction, and if you want to guide the transaction, you need to make sure that the information that you provide to everyone is thorough, consistent, and is in front of an issue.
All right. Well, David, thanks very much. I really appreciate your help in putting this video together.
Sure. Thank you.